Shawn, it's Joe. Calling you with some big news, bro. I'm not a single man anymore. Yeah, I'm taken. It was love at first swipe. Joe, that's great news, man. So you guys planning on getting married? No way, you guys must be super excited. Yeah, we're super excited. But you know who's more excited? My parents. I'm finally moving out. And Mom says she doesn't need to cook for me anymore. My dad gets his additional room back. Guess what? They've offered to help me with a down payment. Hey, Shawn, what do I need to know about gifted funds? Joe, if you're planning on buying a house together, gifted funds from immediate family members such as parents and siblings are allowed. All we need to provide the bank is proof of where the funds came from. We do that in the way of a bank statement, and proof that the funds were deposited into your account. The bank would also require your parents to sign a gift letter to show that they have gifted the funds to you. Okay, well, that's good. But what about from a legal point of view? Like, what if things don't work out between us? Is there anything I need to know legally? Joe, I have just the person who can answer that question for you. Let me call Brikena. Stand by.
Hello, everyone. My name is Brikena Rochette. I am the attorney and co-founder at Rochette Naval Consulting, and I'm so happy that you came to me with this issue. I would be so pleased to talk you through it. Now, you've brought up some critical points here, so let's break it down step by step. Having legally binding documentation for those gifted funds is crucial. For example, a gift letter, which would outline the details of the gift, including the amount, the purpose, which in your case is the down payment of the house, and confirmation that it is indeed a gift and not a loan. Similarly, it can also be helpful to have something known as an acknowledgement of gift for you to sign, acknowledging that you actually received the money from your parents and confirming that it is indeed a gift and not a loan. These types of documents prepared by a lawyer would provide a solid legal foundation and ensure that the gifted funds are properly documented and recognized as such. They also help in case of misunderstandings and disputes in the future. We also need to talk about something called title. And title is a legal term meaning registered owner of real property. Sometimes married people will own their home together. Sometimes they're going to be joint tenants, meaning they both own the whole house. Now, if one of them dies, the other automatically becomes the full owner. This is known as the right of survivorship. This helps avoid some time-consuming legal stuff after someone dies. It can also save money on certain after-death taxes called probate tax. So that's something you might want to consider. But let's talk about what happens if you own it and you're on title alone, but you and your girlfriend end up getting married and it doesn't work out. So in this case, the house would be considered a marital asset subject to division, and your wife would have additional rights if this home was also considered to be the matrimonial home. Now let's talk a little bit about what the matrimonial home is. So in Ontario, if the property becomes the primary residence for you and your spouse, it's considered the matrimonial home. This designation allows for both spouses to have certain rights to the property, regardless of whose name is on the title. For example, if you and your wife get married and you're the sole owner of the house, then you decide to separate, your wife still has legal right to continue living in the house, even though her name is not on the title. You cannot force her to leave without something like a court order. So let's say you want to sell the house that you and your wife own, even though the house is only in your name, you cannot proceed with the sale without her written consent. This ensures that both of you have a say in major decisions about the property. That's why we have this rule. Now, should you be married and end up having children prior to divorcing, that will complicate matters even further because the courts will always consider what's in the best interests of the child. The court may decide that it's best for your children to stay in this family home or the matrimonial home for stability purposes. And despite you being the legal owner, the court could grant your wife temporary exclusive possession of the house to ensure the children's well-being. Anyways, that's the short of it. You should really talk to a family lawyer when it comes to assets as well, because they might be able to provide you some guidance about domestic contracts that could avoid some of the potential pitfalls. So I hope I helped answer some of these questions. And should you have any further questions or concerns regarding your real estate or estate matters, please don't hesitate to reach out to me via email at b.rochette@rnconsulting.ca. Thank you so much for coming to me with your issues, and I hope to help you again in the future. Have a great day. Bye now.